case briefs, and so much more. LSData's got what you're looking for.
The St. Louis Court of Appeals heard Vinyard v. Vinyard Funeral Home, Inc. in 1968, a case that centered on the responsibility of property owners to ensure the safety of their property and address hazardous conditions that could injure visitors. The plaintiff was awarded a $13,000 judgment after slipping and falling on a wet ramp in the defendant's parking lot. The defendant appealed, claiming insufficient evidence, improper verdict instruction, and inadmissible evidence. The parking lot was on 2 levels, connected by paved ramps, with the lower level adjacent to the president's residence and the upper level next to the funeral home. The lot had been paved with an asphalt material, while a clear liquid sealer was used on the upper level, making it smooth and slick when wet. The defendant had prior knowledge of the slippery surface, but had not taken adequate measures to address the issue. During the trial, the court admitted Mrs. Siebert's testimony, which involved falls on 2 similar ramps. The defendant cross-examined her and identified differences between the falls. Citing previous cases, the court supported the admissibility of testimonies from witnesses who slipped on similar surfaces, despite varying locations. The judgment was ultimately affirmed.
Case briefs and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class behind.